Welcome back. Good morning. I'm Gareth Edwards. This is Morning News Today. Both legal teams are expected to make their final arguments to Chief Magistrate Desmond Naya, who will then make a ruling on whether Oscar Pistorius should be released and, of course, under what conditions. Well, let's speak to a legal expert on this, Professor David Unterhalter, to discuss some of the technicalities of the hearing. Professor, good morning to you. A massive pleasure to have you on the show. I would like to, if you wouldn't mind, talk about the difference between murder and premeditated murder in a moment. Many viewers are wondering what is the slight difference. However, if you'll allow me to, I would like to find out if you think that Hilton Botha, the investigating officer in this, if you were involved in this case, would you still want him to be part of this investigation?
Well, obviously it's not an ideal thing that there's now something of a cloud hanging over the investigating officer, but it doesn't really affect the merits of what is being determined in the bail hearing. I mean, ultimately it'll be a question of what has his evidence been and how is it assessed by the magistrate. So regrettable that this has come out about him, but it is ultimately a bit of a sideshow in relation to the merits of the case itself.
As far as what was said yesterday by Mr. Botha in court as well, admitting that he could have tampered with or had not worn shoe covers as far as the investigation is concerned, would that concern a lawyer? Would that concern an advocate?
Well, obviously it's always one of the issues as to whether the integrity of the crime scene is kept in place. And the question would be, well, would there be material contamination that might have come about? I think it's probable that in this case it's the ballistic evidence that's going to be critical rather than the introduction of some foreign DNA matter and the like. So ultimately that'll be a matter for the trial, and it may not be quite as material, but it's highly regrettable that the integrity of the scene seems to have been somewhat compromised.
Do you think he's a credible witness still?
Well, ultimately, I think the question, as with all of these things, is that there will always be vulnerabilities in a case that's presented. One of the features of what's going on at the moment is that it's all at a very early stage. The investigation had only just begun, and so it's unsurprising that there should be certain vulnerabilities in what's being put up. But the same is going to be true of Mr. Pistorius. He has committed himself to a version at a very early stage in the proceedings, and so both the state on the one hand and Mr. Pistorius on the other have, as it were, determined certain positions, and in time they may come to regret them.
Of course, but this is, and we need to point out, this is only a bail application hearing, but whatever is said in court now can, of course, be taken further once the trial per se does begin.
A fundamental point, which is that this is just a preliminary proceeding about whether Mr. Pistorius should be admitted to bail or not. But the point about it is this, that particularly from Mr. Pistorius's point of view, the version that he gives can never credibly be changed. And so his case is more or less set in stone. The state, on the other hand, will carry on their investigation, and the forensics may bring out additional evidence which will serve at trial.
I would like to get clarity, as I mentioned just before we started chatting, that many people are wondering about the difference between the Schedule 5, Schedule 6 pre-med murder and murder. There is a slight difference, but perhaps if I could ask you to explain what are the differences and what are each side actually looking for?
Well, obviously this distinction is very important at a bail stage because it alters the burden that the accused must discharge in order to be admitted to bail. For a Schedule 6, the accused has to show that there are extraordinary circumstances in the interests of justice that should permit admission to bail. And that turns upon the kind of offence that is being charged. And here, premeditation is that you actually act with the aim of killing somebody, as opposed to various other kinds of mental state that you might have, such as foresight of certain consequences that are different from actually aiming to kill. And here, the charge is aiming to kill.
I'm not sure if you are aware, and Professor, I'm quite sure you are, so forgive my ignorance if I ask the question. The name Alan Dershowitz is quite well known amongst legal professionals. Earlier this morning on an international news network, he came out and suggested that the legal system, the judiciary in South Africa, is full of loopholes and is swayed by public opinion and political interference. He thinks that something like that could happen in this case. What's your response to that sort of comment?
Well, Mr. Dershowitz is a great but often controversial legal scholar and indeed legal practitioner. I think in this case he is really not correct. There's nothing that we know of either about the magistrate or the manner in which these proceedings are going ahead which would suggest that there's anything compromised about it at all. I think that's a comment that is simply wrong and is not based on any proper evidence.
Having put forward his version of what happened, and as far as Mr. Pistorius is concerned, his lawyers will of course be looking for bail today. Do you think based on what has been put forward, that he is not a flight risk, that he will stay in South Africa, a proud South African, they will hand over the passport. Would you be calling for bail to be granted?
Well, one must recall here that it's an interest of justice consideration, and what has now been fully developed in the course of the bail proceedings is where do matters stand on the strengths and weaknesses of the various cases. One of the things that the magistrate is going to have to consider is whether, even on Mr. Pistorius' own version, that nevertheless amounts to murder. If it did, then that would be a consideration against the grant of bail. But there will be other considerations such as flight risk and the like, and it may very well be that in the light of the fact that there are clearly highly disputed questions that can sensibly be debated in a trial in due course, that the magistrate might incline towards the grant of bail.
Professor, allow me to put this to you. There are two charges. One is of premeditated murder. The defence is asking for a Schedule 5 charge. Someone was killed in this particular incident. We now know it is to be Reeva Steenkamp. Even if it was someone unknown to Oscar Pistorius, what are the charges that Oscar or Mr. Pistorius could have faced in this? What I'm essentially asking is, what is the minimum charge that Mr. Pistorius could face in this, and could it be dismissed completely?
Well, ultimately, of course, it could be dismissed completely. That will be a question for this as to whether the state can show beyond reasonable doubt that these charges can be sustained on the evidence. But the question is ultimately going to be this: whether or not Mr. Pistorius thought that it was his girlfriend. The question is, if you fire at a closed door, even on the assumption that you think that there is an intruder behind that door, whether that is nevertheless murder. And I think that's going to be a pretty crucial issue in the case.
A final question to you, Professor. On the very first day when the story came out and the police came out to make a statement that they will be pursuing a premeditated murder charge, in your career, is that unusual to see such an extreme charge put forward when not really having had much time to examine the evidence? And part two of my question, if I may, how often do you see a Schedule 6 offender, if, as we've seen, charged with that, actually get bail?
Well, you know, the police have to make an election, and ultimately the prosecution has to make an election, and they do it reasonably on the basis of the evidence as they see it at that point. And I don't think that they can be criticized for taking a view on the matter as they have, given that much of the evidence is compromising and requires explanation, which is what we're hearing from. So I don't think there's anything unusual about that. And as to whether bail will be granted, the reports are very varied on this. When there's a discretion to be exercised, the magistrate will weigh different factors. People are admitted to bail in these circumstances, but of course the onus is on the defence to show the circumstances that warrant bail, and so the magistrate is going to have to be convinced by the defence, not ultimately by the state on this point.
Professor, it's been a huge pleasure in talking to you this morning. Thank you very much for coming in. One of the top legal minds and experts in the country, Professor David Unterhalter.